Welcome, everybody. You are with the Academy of Adoption and Assisted Reproduction Attorneys. We are continuing with our series on our fellows in our different states. This video is to introduce you to the state of Maine. And in this video, you get Chris Berry, our famous fellow from Maine, who can introduce himself and give us more information about the state. Hello, Chris.
Hello, and thank you for this invitation. So, approximately about 15 years or so ago, Berry Law was looking for a new associate. So my mother, Judith Berry, who has been a Maine attorney since the 1990s, invited me to come back to Maine and take over the family practice. At that time, Maine did not have any statutes regarding reproductive law. And one of my first cases in Maine was the case of Nolan versus LaBrie, which established reproductive law as a matter of case law in the state of Maine. A number of attorneys, myself included, realized that it'd be much better to have a statute than just rely on case law. So my firm assisted the Maine legislature in drafting the Maine Parentage Act, which has since been used as a model in other states for reproductive law. We hopefully put quite a bit of thought into it, but it is a fairly complex area of the law in that the goal here is to take the universe of potential parents. Those could be donors of genetic material, a gestational carrier, and reduce that down to just the people that actually should be the parents, the intended parents. This is a complicated area of the law. Maine has studied other states, for example, New Jersey in the case of ABM, and there are very precise statutory requirements in order to get the case used under the statute. The person giving birth, whether that's a traditional surrogate or a gestational carrier, does need to have her own independent counsel. That's not waivable, and everybody needs to have mental health counseling. These are all requirements to try to avoid future issues regarding representation and making sure everybody knows what they're getting themselves into. There are a number of other statutory requirements. If you go to the website, on the link about Maine, there is a discussion about where the statute is, so you can take a look at those. But it is highly advised that you call a reproductive attorney in both your state and the state where your carrier resides to determine what the best path forward is. Pretty much in any state that reproductive matters are legal will require a signed writing, and that signed writing should be compliant with the state's laws. In Maine, we're fairly flexible in that we have jurisdiction based upon either the intended parents residing in Maine, gestational carrier residing in Maine, or some other significant act occurring in Maine, such as the birth. It's not uncommon that people will live on one side of the Maine-New Hampshire border, but give birth on the other side. I am dual licensed in both Maine and New Hampshire for this reason. And the more complicated the case gets, the more necessary it is to have an attorney. Not every court is as familiar with assisted reproductive law as members of the American Academy of Adoption and Assisted Reproductive Technology attorneys. I joined the Academy about 10 years ago, and I found that it's been invaluable because it's not common that people will reside in the same state that their carrier is located. It's quite common people will match across state lines. The wonderful thing about the Academy is that if you contact an Academy member in your jurisdiction, they can reach out to another Academy member in the other jurisdiction and give you some information about how your state's laws mesh with the other state's laws. That is by far the best thing about the Academy, is the ability for the attorneys to work together and determine how a case can proceed, or if it can proceed. Maine is a very friendly state for reproductive rights. In fact, I'd probably say one of the biggest issues we have is that we're almost too friendly, in the sense that what we can do in the courts is practically infinitely flexible for what the parties need, assuming we're in compliance with the statute. For people from outside the United States. Maine does have quite a bit of understanding that people in other countries have different laws. And it's generally not a problem to have more than one court order in the state of Maine, one in compliance with the Maine domestic law, and then another order for compliance with the foreign country's law. So quite a few of my clients are from overseas, and their attorneys in their local jurisdiction appreciate that we can get a court order in compliance with that foreign state's laws. In Maine, we have practically no restrictions on who can be a parent. Um, if you have a family situation that feels unique, by all means, give us a call and we can give you a free consult regarding your situation and what's feasible. But again, the biggest thing is we need a written contract. And it's a statutory requirement in Maine that both the intended parent or parents and the gestational carrier have an attorney. This is important because these are significant legal rights that are being affected. And in Maine, like many states, parental rights are considered the most fundamental constitutional rights. And while we certainly hope that the case does not become contested, if it does become contested, strict statutory compliance is going to be necessary to make sure that the result that the parents had at the beginning of the process is the result they get. For people from other jurisdictions where an adoption is necessary, Maine does allow for an adoption in reproductive cases. It's in fact required if it's a traditional surrogate. That's where the woman who's giving birth is also using her egg to achieve pregnancy. That's relatively disfavored for a number of practical reasons, primarily emotional and mental health reasons, but it is allowed. Just be aware that if the intended parents do not have some sort of genetic connection to the child, a home study may be required. And that's something that should be done well in advance of trying to achieve pregnancy, because it can be a lengthy process. In an adoption situation, compliance with an interstate compact or placement of children might be necessary. So you're well advised to speak with an attorney from your home jurisdiction as well as where the carrier resides. Again, it's very common that intended parents and gestational carrier are two different states. And it's also quite common that one or more genetic donor may be from a different state, and the medical procedures might be in a fourth state. So particularly when you have multiple states involved, it definitely is worthwhile to make sure that you have an attorney that can consult with attorneys in all different jurisdictions to make sure you're in compliance with the laws. Some states, reproductive matters are in fact illegal, and that you may be more restricted in what sort of legal arrangements you can make.
Thank you, Chris. We appreciate it. And for all of you that are listening, please know that each of our fellows, including Mr. Barry, are on the website for the Academy. That website is www.adoptionart.org. And you can find all of his contact information. And just, I mean, he made it clear to you, it's best to call him to figure out the nuances. Don't try to guess based on these videos. But it was a pleasure meeting you today, Chris, and we encourage the public to contact you with any questions regarding Maine. Thank you.
Thank you.